Cody is an attorney from Firearms Policy Coalition, and he is taking time to come on the show and talk about something very, very important to us. So, Cody, are you there?
Yes, sir. I'm here.
Hey, man! Thanks so much for coming on. And everybody knows about Firearms Policy Coalition. They do excellent work. We partner with Firearms Policy Coalition on everything that we do legislatively. They've been such a wonderful partner to San Diego County gun owners. I cannot thank you guys enough. You've done a wonderful, wonderful job. And specifically what I wanted you guys to come talk about, Cody, is the Carolero case. It's a little more complicated than most decisions, so I really, really wanted to clarify. And I think maybe if you could just start with just giving us a brief, like what just happened with the Carolero case, which, by the way, is the case against SB2. We're trying to get rid of the CCW ban that SB2 brought.
Of course, yeah. So one small note. So I'm actually president at FPC Action Foundation. I am an attorney, a litigator, but I also work. No. Of course, and I work really closely with FPC, help manage the litigation agenda and our caseload, including the Carolero case that I've worked a bunch on. So basically, what just happened was, when we initially filed a lawsuit against SB2 and all of these so-called sensitive place restrictions that California enacted in response to Bruin, we initially got a preliminary injunction, which just basically means that the court paused California's ability to enforce its law. Preliminary injunctions are just designed to preserve the status quo. And so essentially it's the court going, hey, I'm going to put a pause on this until we can get to the full, merits of the case, until we can decide the bulk of it completely. So we were successful. The case went up. And it went to the Ninth Circuit. Of course, your listeners are intimately familiar with the Ninth Circuit and what sometimes we can expect from there. But this was a little different. So the Ninth Circuit actually held some parts of the injunction and essentially overruled, if you will, some parts of the injunction, or basically decided that they shouldn't be in place. So it was a little convoluted in that basically the Ninth Circuit went through each specific location restriction that was challenged, analyzed each one, and then decided whether or not the injunction stood or didn't stand based on each individual location and each individual part of the rule. So that's what just happened. And basically now it's, planning for next steps.
Okay, so before we get to the next steps, because I do definitely want to talk about that. Basically, SB2 listed, it was about 20 points, 24 points, something like that. A lot of what they listed were areas that were already, carry was already banned there, maybe by federal law or existing state law. But then they expanded the carry ban to a number of other places, which basically amounted to every place outside of your home. I mean, it was really impossible to carry if if that list had stood. You got an injunction against the places that were affected by SB2. There were other places like courthouses and whatever that was already in place. So the injunction was the expansion of the ban. Now let's start off with, and then the court decision that just came out. Basically, about half of the ones they said, yeah, we're going to keep the injunction in place, and the other half they said, no, we're not going to keep the injunction in place. So one of the ones I want to start out with was there was kind of this catch-all, which I think people are referring to as the vampire rule. Where if you're a business, you have to put out a sign that says you're okay to carry here. Otherwise, by law, it's not legal to carry there. Now, is that enjoined, or is that not enjoined?
The Ninth Circuit upheld the injunction as to not allowing California to enforce that part of its rule. So we call it the vampire rule as somewhat of a joke because it's right. You have to be given permission to enter. But yes, the idea is basically what California did was it reversed, what has been long-standing practice in everywhere in the country, which is, you can carry, if you're otherwise legally able to carry your firearm, you can carry it into private businesses that are open to the public. so long as that business does not specifically prohibit you, right? So before it was, if there was a sign that said no carry, then you couldn't carry in those places. California is one of the many states that, in response to Bruin, flipped that. And so basically what it would have required was some specific permission from the property owner to, quote unquote, allow you to carry your arm on that, again, private property, but private property that's specifically been opened to the public for whether it's a business or something to that end. So the Ninth Circuit upheld the injunction for the California portion of that. This case is consolidated with one for Hawaii, and the Ninth Circuit wasn't as kind to the Hawaii one. Basically, what the court reasoned was that California's law was very restrictive in the manner in which a private business owner could permit firearms. And the court basically determined that based on a review of history, a flawed review of history, which I can, get into if you want to. I can, talk about the two historical statutes they looked at. But basically, the court said there were several ways that a private business owner could allow people to carry because California didn't provide for other ways to allow private business owners to allow people to carry. That California's law was too restrictive and didn't follow history. So that's a long way of saying that California's vampire rule was enjoined by the Ninth Circuit.
So California basically said you have to have this government approved sign up, and the court said nope, that's too restrictive. So that is not being enforced. Hawaii said, hey, there's actually a couple different ways that a business can tell their customers that they're able to carry there, and so they upheld that. They said they upheld that. They said that's fine. You can do that, which is not great news. I mean, it's going to be fairly easy for the state of California to just say, all right, great, then we'll pass what Hawaii passed, and it'll if it passes muster, then great. Am I wrong there?
No, you're not, and it is somewhat Pyrrhic in that sense, and that's where the problem with the historical analysis comes in. So the Ninth Circuit basically. Interestingly, after Bruin, all of these courts are doing what we in the legal space call originalism, right? It's looking to the text as what it meant when it was drafted and ratified. So for the Second Amendment, that should be 1791. The Ninth Circuit looked to the historical statutes to determine whether or not there was a, analogous one to either California or Hawaii's law. The problem is the laws that the Ninth Circuit relied on are not at all applicable. So they relied on a 1791 New Jersey statute that dealt with landowners being able to prohibit people from possessing arms on their property, but that statute was specifically aimed at hunting season and was aimed as it was a hunting ordinance that basically was prohibiting people from being able to hunt armed on private land if the private landowner didn't want the arms on their land. So that's nowhere near similar to general businesses that are open to the public.
Yeah, so it's not over, but that's the case they made, and it's a ridiculous one. It'll get beat, but that is the case. Before we get to the other one, what I really wanted to do is get really nuts and bolts with our listeners so that this is a resource for them. So I wanted to talk about, we have a list here of places that we believe carry has now been banned. Can we just read off those and you just confirm that this is the new list? Is that okay, Cody?
So I actually don't have the list in front of me. I also think that it would be beneficial for people to go and look directly at the court opinion and order. Some of the reasoning is convoluted, but I can't give people legal advice. I could tell you kind of like my interpretation of the opinion, and I can tell you, I can, have some of the areas where California kind of affirmed the injunction, and so I can, talk about those.
Tell us what you can tell us. Yeah.
So California basically affirmed our injunction as it applied to, hospitals and similar medical facilities, as to public transit, as to gatherings that require a permit. Those are ones like public gatherings where you have to get a state permit to hold the gathering. Places of worship, financial institutions, and then parking areas and similar areas connected to those places, as well as that private property rule that we discussed. So,
that's where the court agreed. The court said that's unenforceable.
Correct. That is where the court maintained its injunction and said, California, for the life of this case, you can't enforce the injunction enough. You can't enforce your prohibition in those places.
Okay, so where should they go to read the decision, Cody?
So if you go to firearmspolicy.org, there's a tab at the top that says Our Work. You can click on that, and then you can scroll down. That's all of FPC's active cases. The Carolero case is there. You can go to that case page, and the opinion is on the case page.
Great.
You can also look at FPC's social media at Gun Policy. You know, we posted about it. They posted about it quite a bit.
Perfect. While you're there, make a donation. These guys are doing the Lord's work. So thank you, Cody. Thanks for watching this clip from Gun Owners Radio. If you're watching mainstream media, you're not getting the truth about guns. Gun Owners Radio is the easiest way to stay on top of the Second Amendment fight, the fight for your self-defense rights. You can watch our live stream on YouTube every Sunday from 4 to 6 p.m. California time, or if you're in San Diego, AM 1170, FM 96.1, The Answer. We're also available on your favorite podcast platform. Just search Gun Owners Radio and you'll find our show. Like and subscribe to help defend and restore the Second Amendment, not just in California, but across the country.